Well, I bet I do.
Well, then you're in contempt, young lady, and you've got 30 days. So you're not what?
Whoa.
Get back! Get back!
You just said I got
Get back! That's another 30 days. That's 60 days.
That you, Jason Brian Dalton, be remanded to the custody of the Michigan Department of Corrections and be sentenced to a period of life in prison without the possibility of parole.
This case involves Ebony Burks, a 32-year-old woman charged with domestic violence and assault in Ohio. During her appearance at the Elyria Municipal Court, Judge Gary Bennett informed Ebony that she was prohibited from contacting the victims involved in her case. It was at this moment that the situation took an unpleasant turn.
I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact with Tiffany Castro. No contact means you can't call him, you can't write him, you can't text him, you can't email him, can't leave a message on some social media, you can't go visit him.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with
I'm sorry, no need you say nothing.
If you live with Mr. McCrae, you cannot return to that residence.
Ebony was particularly upset by the restriction that prevented her from contacting her grandfather, Shedrick McCrae, with whom she lived. This directive caused her to lose her composure, and she began to argue with Judge Gary Bennett, directly challenging his instructions.
How you gonna tell me I can't go to my house?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you've got 30 days. So you're not what?
Whoa.
Get back! Get back!
You just said I got
Get back! That's another 30 days. That's 60 days.
Initially, Judge Bennett issued a 30-day sentence for contempt of court, hoping it would resolve the situation. However, Ebony continued to speak aggressively and argue with the judge, prompting him to increase her sentence further in response to her continued defiance.
Got anything else to say, Miss Burks? That's 300 days!
As Ebony persisted in speaking out and arguing, Judge Bennett escalated the situation by increasing her prison sentence for contempt of court to 300 days. Arthur Hage, a church pastor, and his estranged wife, Lillian, were in family court in Putnam County, West Virginia, for a divorce hearing overseen by Judge William Watkins III. The proceedings began with Judge Watkins sternly warning Hage to behave appropriately in court. However, the situation was complicated by Hage's refusal to sign a deed that would allow for the sale of their marital home.
Mr. Hague, if you say one word out of turn, you're going to jail. Do you understand me? Yes or no?
Watkins was already angry with Arthur Hage because Hage had disclosed personal information about him to the media.
Morning, I now see an article from your little buddy Smith with a picture of my home. My home.
Even though Hage's name was not mentioned in the article, which primarily focused on Judge Watkins's involvement in a local homeowners association, Watkins continued to express his outrage during the proceedings.
Disabled, she's there alone, and you disgusting.
During the proceedings, Judge Watkins even threatened Hage.
You are responsible. I'm holding you personally responsible for anything that happens at my house. I promise you, if I so much as see somebody breaking at my home, my wife, my family, you and me are going to have a problem. It is personal. You have threatened my family. And I promise you, you will not hear the end of it from me.
After giving Hage a piece of his mind, Watkins regained his composure and refocused on the divorce case at hand.
Sorry, Miss Wallace, Miss Hague, I'm sorry, I cannot tolerate that circumstance.
Eventually, Judge Watkins ordered Hage to sign the deed and also mandated him to pay $500 to a third party to accelerate the process.
Mr. Hague, pay him the sum of $500 for his services no later than Friday.
However, Hage disagreed with the ruling.
I'll sign it. I don't have that kind of money. I don't have the money.
Despite Hage's objections, Judge Watkins ruled in favor of Lillian Hage, ordering the pastor to cover several expenses once the house was sold. Unhappy with the outcome, Hage later filed a complaint against Judge Watkins with the Judicial Investigation Commission. Subsequently, it was revealed that Judge Watkins had a history of berating litigants and attorneys in his courtroom. This led to his censure for 24 violations by the West Virginia Court of Appeals, and he was ultimately suspended without pay for the remaining 4 years of his term. The crimes committed by Eldon are indeed unacceptable, but their behavior in court is even more chilling, likely to shock anyone observing the proceedings.
Henry T. Eldon, Henry T. Eldon, Henry T. Eldon. I have called him thrice. I have no response. Get up here in this seat right now.
The court reporter has to be established before anything can proceed.
Henry identifies as an American national, subscribing to the sovereign citizen belief that he is above the common laws of his country. Listen carefully as he explains his perspective.
I'm not acting. I'm a witness. This is an American national.
Eldon was accompanied to court by a friend, also a member of the sovereign citizen movement, who recorded the entire proceeding on his phone and even defended Eldon's disruptive behavior in court.
I'm a witness today of this. Okay. I'm a witness, okay? Okay, what I'm saying is he is present, and he's chosen not to step up there. He's asking not for an appointed lawyer. He doesn't need an attorney, okay? So I'm just a witness that he is present here, okay? And I will repeat that when the court reporter begins. For the record, I'm a witness.
Sit down.
This is
now,
Ted Eldon.
You sit down. Not say another word.
That's Ted Eldon.
After some back and forth exchanges, Eldon reluctantly and only partially complied with the judge's orders. However, having had enough of Eldon's defiance, the judge decided to take further action.
You are going to be held in contempt.
All right, Mr. Eldon, can you just stand up for me, please? Turn around and place your hands behind your back, if you would.
And who are you? And do you have a warrant, a signed
I do
warrant?
not have a warrant. I've just been made aware by the judge that he wants me to take you into custody for obstructing judicial process, okay?
Eldon escalated his defiance by demanding to see the oath of office, acceptance letters, and acknowledgments from both the judge and the prosecuting attorney. He also insisted on knowing the names of everyone present in the courtroom. At the next scheduled court hearing, Eldon failed to appear, leading to the issuance of a bench warrant for his arrest. Consequently, he was sentenced to 2 weeks in jail. Sean Blitchington, a 48-year-old struggling with alcohol addiction, had a troubling history before 2018. He had been arrested 5 times for driving under the influence, resulting in the revocation of his driving license. Despite this, Sean continued to drive and drink. On July 22, 2018, after consuming excessive alcohol, Sean Blitchington took to the streets in his truck despite having his license revoked. In an intoxicated state, he drove on the wrong side of US 301 in Bryceville. This reckless maneuver resulted in a tragic collision with a vehicle carrying 21-year-old Ryan Kennedy and 22-year-old Bailey McKnight. Both Kennedy and McKnight were killed instantly. The impact of Blitchington's actions extended beyond these immediate fatalities, deeply affecting the community and the families involved. After the crash, Blitchington fled from his vehicle, but was later found by the police hiding in a ditch and was immediately arrested. Sean Blitchington faced charges of driving under the influence, manslaughter, driving on a permanently revoked license, and leaving the scene of a fatal crash. During his trial, Circuit Judge James Daniel emphasized that Blitchington's decision to drive drunk was intentional and had catastrophic consequences for the families involved. In her victim impact statement, Susie Kennedy expressed profound grief, stating she felt as if she had died that day too, but was left unburied. She labeled Blitchington a thief for robbing her of precious future moments with her daughter and grandson, Lawson. Blitchington expressed remorse and apologized to the victim's family. He was ultimately sentenced to 60 years in prison, meaning he would be 108 years old by the time he completed his sentence. Judge John Woolley is presiding over the case of a 16-year-old defendant who violated his probation in a juvenile court in Vancouver, Washington. The teenager, accompanied by his mother, but without his attorney present, shocked everyone when asked about his attorney's whereabouts by expressing his desire to represent himself.
Like to fight for myself. not have an attorney.
However, Judge Wool disagreed with the teenager's decision to represent himself.
That's not a smart play. That's like going out on the field with the New York Yankees and you've never even learned how to play baseball.
Despite the teenager's insistence on representing himself, Judge Wool maintained that he should have legal representation. He clarified that legally, a juvenile cannot plead guilty without an attorney assisting in the proceedings.
I'm not going to do that. You're going to have an attorney assist you in this matter.
But I'm not going to let him fly solo and walk into a court of law and try to practice law.
The teenager attempted to reason with Judge Wool. Still, the judge emphasized the importance of his role in protecting the defendant's constitutional rights, particularly stressing that these protections were in place, even if the defendant did not fully understand them.
We're sending it over to Tuesday.
The court clerk attempted to signal the teenager and his mother to be quiet as they began to speak, but the confrontation quickly escalated. Judge Wool, visibly frustrated, ultimately lost his temper and bluntly expressed that he was trying to help the defendant.
I'm doing my job, sir. My job requires that I protect your constitutional rights. You as an American citizen. That's my charge. And if you're too stupid to know that what I'm trying to do is protect you.
Moments later, Judge Wool apologized, acknowledging that he rarely lost his temper.
My apologies to everyone in this courtroom. I very rarely lose my temper, but when I do, it's usually because someone is too stupid to recognize that I'm trying to help them.
Judge Wool's apology appears backhanded, and his assertion that he rarely loses his temper isn't entirely accurate. Over a 2.5-year period, Judge Wool was cited for multiple incidents of discourteous and impatient behavior. Ultimately, his courtroom conduct led to a public reprimand by the Washington State Commission on Judicial Conduct. In Shelbyville, Kentucky, a divorce hearing has taken a heated turn. The husband has filed a motion requesting that his ex-wife be mandated to secure her prescription narcotics inside their shared home, where they reside with their children.
And they're wise enough not to go around taking... I only interviewed the children for a few minutes, and I get it that they're okay with not taking... Your children are very bright, and I can't even believe you would make that motion.
The attorneys brought to the judge's attention that one of the children had expressed thoughts of hurting themselves during the divorce proceedings, raising significant concerns about their mental health.
I can appreciate what you're saying. They are good children, but there has been some mental health concerns, and we just think it's good practice to do that.
Even with this concerning information, the judge remained unconvinced, insisting that there was insufficient evidence to support the need for securing the prescription narcotics.
It's not a year-old who'll pick up a pill off the floor.
The frustrated father presented a reasonable counter-argument, but the judge remained unconvinced and did not accept it.
Your opinion on that, I'm sorry, is just wrong. Intelligent children have a rights just as well as unintelligent children.
You have no evidence to put before me that these children... listen, you need to stop talking.
I'm
you
sorry.
Really do.
I disagree with you on that.
Well, fine, you disagree, but you're not up here. I've ruled on that.
Unable to hold back his opinion any longer, the father had something to say to the judge.
We're ridiculous.
The judge promptly held him in contempt of court and reprimanded him for his behavior.
Contempt of court. You don't tell me that I'm ridiculous. Do you understand me? Have a seat over here, bailiffs.
The bailiffs escorted the father to a seat in the courtroom, but the passionate father refused to give up. He continued to plead his case, emphasizing that the well-being of his children was at stake.
You heard yourself that one of my children talks about committing. Yeah, they're in a house full of narcotics that are unprotected. Do you not see that that could be an issue?
He pointed out that having unsecured prescription narcotics around children could pose a serious risk. However, the judge remained firm and dismissed his concerns. Lee Rios is facing charges of murder in Massachusetts, USA. In 2015, Rios and Jonathan Guerra, both members of the Latin King Street Gang, murdered 18-year-old Kenneth Lopez. The murder was strictly ego-driven. Rios believed he had to kill Lopez because he felt disrespected, showcasing the dangerous consequences of gang-related violence.
Mr. Lopez lost his life because he had hit on Mr. Rios' ex-girlfriend and because he showed him disrespect.
Rios lured Lopez out of his house, and they shared a cab to the location where Lopez tragically lost his life. Upon arrival, they were joined by 3 other Latin Kings gang members. The assistant district attorney, Max Bennett, informed the court that Rios fired a total of 5 shots, with 4 of them striking Lopez, including 2 fatal shots to the head. Rios's actions were already heinous, but his demeanor in court was also less than desirable. He appeared disinterested in the proceedings. Despite denying the charge charge in Springfield District Court, the case proceeded to Hampton Superior Court. Rios was ultimately convicted of first-degree murder by a jury and sentenced to life imprisonment without parole.
Count 1. Jury having convicted you of first degree, sir, I'm sentencing you to NCIC Junction for the term of your life without the possibility of.
Rios's cold demeanor and lack of remorse serve as a reminder of the destructive path that comes with involvement in the gangster lifestyle. Witness the chaos as Call of Duty and similar games turn the battleground beyond screens into all-consuming addictions.
Count 7 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did Dorothy Brown. If guilty of this offense, it is a felony punishable by up to life in prison.
On February 20th, 2016, a heartbreaking cacophony of chaos unfolded in Kalamazoo County, Michigan. 8 lives were shattered by gunfire, and 6 souls were tragically lost. Amidst the wreckage, one name echoed: Jason Dalton. Overwhelmed by grief, mourning families sought justice in the courtroom, their silent agony echoing through the halls.
My name is Lori Smith, and Richard was my husband, and Tyler was my son. My husband was my best friend, my soulmate, the love of my life. He was my person. On our wedding day, he surprised me and had a song called "Forever's as Far as I'll Go" played for me. To this day and beyond, I love him with every ounce of my being. Our love for each other is for eternity, and no one can or will ever change that. No matter what life threw our way, we were always there for each other. He was a loving, caring, thoughtful, and intelligent man who would do anything for anyone. He was a friend to everyone. Rich had a laugh that was contagious. He loved to make people laugh. He always knew just what to say and what not to say and when. He made me laugh. He held me when I cried. He told me everything would be okay when times were tough. And he was always there, no matter what. We started out remodeling houses together. Then we got married and had children. I always counted on him and him on me. We were a team, as soulmates, as parents, and as friends. Our kids were our world, and Rich was an awesome father. His kids and I came first. Everyone who knew him knew that. Whatever the kids had going on, we were there. And when schedules overlapped, he went to one kid's event and I went to the other. Family and friends often came to us when they had a problem or needed help, and he and I would team up and took care of whatever needed to be done together. One of the things we loved to do is to go up to Silver Lake, Michigan as a family, with my extended family too, and play on the sand dunes and around camp. Rich had grown up around ATVs, dune buggies, and off-roading, and loved to share his passion. Rich and I had plans for the future. We were going to go places, discover things, continue to make memories together, continue sharing in our kids' lives, being a part of their futures as they finished school, started families on their own, and realized their dreams. My son was loving, caring, funny, smart, and thoughtful. He too was a friend to everyone, including me. I could not have been more proud of him and the respectful young man that he was. I love him to the deepest of my core. He was and is my precious baby boy. His smile lit up the room, and he often greeted loved ones with rib-crushing hugs. Tyler was a very talented athlete and could do anything he put his mind to. He loved his family, and I have a big family, and we all loved each other very much. Tyler was especially close with his sissy, as he called her, and with my twin sister's 3 kids. In fact, my twin sister's 3 kids were more than just cousins. They were siblings. They all grew up, went to school, and did practically everything together. They were very similar in ages. Tyler's friends were important to him too. And that includes his girlfriend, Alexis. Tyler told me when he first met Alexis that he wanted to do things right and not screw it up with her.
When confronted with their own criminal behavior, individuals may fail to recognize themselves, but their reactions can often be discerned from their eyes and facial expressions.
By a sentence up to life imprisonment. Count 2 of the complaint. It's alleged that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did carry or have in his possession a firearm, to wit, a pistol, at the time he committed or attempted to commit the felony of murder. If guilty of this offense, it too is a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 3 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did murder Mary Jo Nye. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 4 alleges on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did carry or have in his possession a firearm, to wit, a pistol, at the time he committed or attempted to commit a felony, that being open. If guilty of this offense, it is a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 5 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, the defendant did Barbara Hawthorne. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 6 alleges that on February 20, 2016, in Kalamazoo County, State of Michigan, Texas Township, that the defendant did carry or have in his possession a pistol at the time he committed or attempted to commit the felony of open murder. If guilty of this count, it's a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 7 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did Dorothy Brown. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 8 alleges at that same time, date, and place that the defendant did carry or have in his possession a pistol at the time he committed or attempted to commit the felony of open murder. If guilty of count 8, it's a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony. Count 9 alleges that on February 20, 2016, in the city of Kalamazoo, Kalamazoo County, State of Michigan, that the defendant did murder Richard Smith. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 10 alleges at that same time, date, and place that the defendant did carry or have in his possession a at the time he committed or attempted to commit the felony. If guilty of this offense, it's a felony, punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 11 alleges that on or about February 20, 2016, in the city of Kalamazoo, Kalamazoo County, State of Michigan, that the defendant did Tyler Smith. If guilty of this offense, it is a felony, punishable by up to life in prison. Count 12 alleges at that same time, date, and place that the defendant did carry or have in his possession a firearm at the time he committed or attempted to commit the felony of open murder. Guilty of this offense, it's punishable by up to 2 years in prison consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 13 alleges that on February 20, 2016, in Texas Township, Kalamazoo County, State of Michigan, that the defendant did make an assault upon A.K., a minor child with intent to commit the crime. If guilty of this offense, it's punishable by life or any number of years. Count 14 alleges at that same time, date, and place that the defendant did carry or have in his possession a which time he committed or attempted to commit a felony, that being assault with intent to. If guilty of this offense, it's a felony punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Count 15 alleges that on February 20, 2016, in Richland Township, Kalamazoo County, State of Michigan, that the defendant made an assault upon Tiana Carruthers with the intent to commit the crime of murder. If guilty of this offense, it's punishable by up to life or any number of years. Count 16 alleges at that same time, date, and place that the defendant did carry or have in his possession a at the time he committed or attempted to commit a felony, that being assault with intent to murder. If guilty of this count, it is a felony punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction.
Humans can occasionally serve as psychopomps, guiding others to confront their mortality when faced with someone they attempted to harm or kill.
A couple minutes go by and we don't even make it to the park almost. We're like right there by the sidewalk. And I seen him coming and I saw it.
No, they gave bags. These old people, they have these old black bags. They're called they're black. They're black bags. And people drive around and you look at them. It gets real like, hey, it's time people look. And then that's when to tell people it's time to get to temple.
Mr. You need to listen to your attorney.
Yeah, you need to get to temple because you need to get going because it's called intimidator bags.
You need to be quiet in today's proceedings, okay?
Yeah.
If you have anything to say, you whisper to your attorney. That's today's rules, okay? Okay.
So, Ms. Carruthers, are you okay? Or do we need to take a minute?
Take it.
All right. We're going to call a recess.
Take it.
Court, down in the holding.
We're here, honey. You're okay. You're okay, baby. You're okay.
In the chambers of justice, where fate hangs in the balance, the firm boom of the gavel awaits, ready to tip the scales of righteousness should guilt be proven.
And secondly, are you prepared at this point for the court to engage in sentencing? It's a preliminary matter. I would note that a number of people have spoken to me outside of court, and I've heard now in court the question, why? And that, as best the court can see, is only going to be known to you and to our Creator. What I can also say is that by your actions, Kalamazoo has been given an opportunity to show the world, the words of Archbishop Tutu, that goodness is stronger than evil, that love is stronger than hate, that light is stronger than darkness, that life is stronger than. That victory is ours because of Him who loves us. It's a court sentence as to counts 1, I have to go through each of them individually. Count 1, that you, Jason Brian Dalton, be remanded to the custody of the Michigan Department of Corrections and be sentenced to a period of life in prison without the possibility of parole. This is to be served consecutive to those sentences that will be given in counts 2, 4, 6, 8, 10, 12, 14, and 16. Also, they are to be concurrent. It is to be concurrent with counts 3, 5, 7, 9, 11, 13, and 15. As to count 1, you are to be assessed indigent defense fund fee of $1,795, court costs of $1,000, $130 crime victim fee, and $68 state costs. If there is, in fact, restitution that's owed, that is left open at this time upon application of certain institutions. I would take the opportunity to note that as part of the process of this community pulling together, a number of funds have come forward to assist the victims in their medical and ancillary costs. Those institutions, I believe, should be given an opportunity to recoup such funds as they can from you. Plus, if the victims have additional costs associated with the crimes in which you were convicted, they should be allowed likewise to assess those costs against you. As to count 2, court will order that you, Jason Brian Dalton, be remanded to the custody of the Michigan Department of Corrections for purposes of classification and incarceration for a period of 2 years. This is a mandated offense, and this sentence is to be imposed or is entitled to have credited 1,080 days that you have currently served. This is to be concurrent with counts 4, 6, 8, 10, 12, 14, and 16. In addition, the court is going to order that you pay $68 state costs for that count. As to count 3, the court will order that you, Jason Brian Dalton, serve a period of incarceration with the Michigan Department of Corrections for life, as is mandated, and that is to be consecutive to counts 2, 4, 6, 8, 10, 12, 14, and 16. It is to be concurrent with sentences imposed in counts 1, 5, 7, 9, 11, 13, and 15. And there is, in fact, a state cost of $68 imposed as to that count. Count 4 is also what's called felony count. You, Jason Brian Dalton, are to be remanded to the custody of the Michigan Department of Corrections for sentencing. Period of 2 years as mandated by statute. That sentence is entitled to 180 days credit, and it's to be concurrent with sentences imposed in 2, 6, 8, 10, 12, 14, and 16.